This is Earl White, real estate attorney. This is a video for information that you need to know about when you are conducting a transfer of ownership during the process of refinancing. We're going to discuss legal considerations and practical considerations that you need to think through when conducting this deed transfer. We'll discuss the steps you'll take as part of transfer ownership via the deed, mistakes to avoid, and also we'll discuss some of the costs because I'm sure you're curious about the cost of it. Okay, when you are doing a deed transfer during the process of refinancing, you should consider the reasons that you're doing this deed transfer. Most often you'll be taking someone off the title, so we'll discuss that now. One reason you may want to take people off the title during the refinancing process is because that person on title might have current or prior legal issues, for example, lawsuits, court judgments, delinquent taxes. And if you have an opportunity to take them off the title, like when refinancing, then that can help protect the value of the property in the long run by only leaving the person on title that will not have these legal problems and therefore not threaten or harm the value of the property. Another reason that you may do the ownership change as part of refinancing is oftentimes people join title at a real estate closing for the sole reason being that they were required for credit purposes or meeting certain debt to income ratios. So they only came on title for purposes of effectuating the mortgage. That person who only came on for those reasons, oftentimes since they're there for that, they aren't contributing to mortgage payments or real estate taxes. They're not helping pay utilities. They're not maintaining the property. They just came on to effectuate the transfer, good-hearted to help a friend or family member to complete the process, but now they're not contributing. And so as everyone's on the same page, this is a time for them to come off the title. So the person who is truly invested in this property will then become the sole owner. Another reason you may do the deed transfer at the time of refinancing is this might be the first opportunity to actually do this. And before you wanted to, maybe both owners wanted to, but now this is the first opportunity. The reason being is that most mortgages, assuming there's a mortgage on the property already, most mortgages have what's called a due on sale clause. What a due on sale clause means is that if you were to transfer ownership of the property without paying off the mortgage, then the bank could call the loan, whatever amount of balance is due immediately, and then you would have to pay the loan back at that time. If you fail to pay the loan back at that time, the consequence would be foreclosure. They would foreclose on you for not paying the loan back. Now, there are federal exceptions, parents to children into a trust which you are the sole beneficiary. Upon divorce, you have a divorce decree. So there are federal exceptions for this due on sale clause, but if none of them applied, you may not want to take that risk in the past about potentially getting hit with that due on sale clause. And therefore, once you're refinancing, the current mortgage will be paid off. So there's no issues about due on sale. And then now you have the opportunity to create a new deed without running afoul of the prior mortgage. Let's discuss the steps for completing a deed transfer during the process of refinancing. First step, quite obviously, is you should get pre-approved for refinancing. So you will contact a lender, a bank, a loan broker, someone that will evaluate your financial circumstances to ensure that you are qualified for the refinancing. Otherwise, the rest of the steps don't matter because you're not qualified. So step one, make sure you're qualified before moving too far down this process. But once you're qualified, then now it's time to move to the next steps of the deed transfer. The second step is going to be to hire an attorney. An attorney is going to draft the deed paperwork for you. They will review the title report if there was one produced, which most likely as part of this, you selected a title company to run title search. So the attorney will draft the deed, supplemental paperwork. The documents drafted to this point are the deed. So you hire the attorney to draft the paperwork. So you have a deed, get rep form, affidavit of consideration. When you're hiring the attorney, you want to make sure you're using qualified real estate attorney in the state that you are completing the deed transfer in. Some states may not require them. So Massachusetts, New Jersey, New York often have either attorney requirements or it's common practice. States like Florida, Maine, or Pennsylvania, you may not need that. So hiring a real estate attorney, let's call that step two. Step three is then drafting the paperwork. So there's three forms that you will need to prepare as part of completing the deed transfer. The first form is the deed itself. You will list at the top the grantor, who the current owners are. You will list the grantees, the people becoming the owner, and there's various other promises made as part of the deed transfer. And also you will attach the legal description. So the deed, the legal description, lot and block number, the parts of the legal description that refer to a survey, so the boundary lines. So that would make it a valid and recordable deed. So you need that deed signed and properly prepared. Additional form is a get rep form. A get rep form is a seller residency form the state of New Jersey requires as part of recording any deed. So there's different get rep forms. There's ones if you live out of state, and there's ones if you live in New Jersey. So you just use the appropriate form as part of the recording. Third document that is required for recording the deed is what is called an affidavit of consideration, which is also a form required by the state of New Jersey. That'll have to be notarized. It will also include the specifics of the property, and it will have to be signed by one of the current owners of the property as part of the new deed being recorded and specifying the new conveyance. But so those three forms: deed, get rep form, affidavit of consideration that your attorney or company will assist you in drafting and executing. Step 4, you get the documents, the ones I just mentioned, signed and delivered to the title company. Most often as part of these transactions where you're paying off a mortgage and then getting a new one, the attorney will not be the one that records it. It will be the title company. So you get the signed documents, put them into escrow with the title. Once the refinance is fully clear to close, fully approved, not just pre-approved, not just in the process, completely ready to close on the refinance, the title company then will have the recorded deed in one hand. They'll have the money and financing from, if there's going to be down payments, or from the lender, so that any money required, the title company will have that in their hand, and then they will deem the refinancing closing completed. The last step is recording those documents we discussed earlier. So that's the deed, that's the get rep form, and that's the affidavit of consideration. Most likely, recording is going to be handled by the title company. The cost, there's a title company will likely charge a cost as part of the recording, and the recording will be done first in the county. So they'll take those documents, usually done via e-recording or mail, most often e-recording, submitted the e-recording to the county. In approximately 30 days or less, the county will update their records online. So you go on the county deed register and you'll find that document with official instrument numbers, book numbers, page numbers. So now you're officially recorded. And then approximately 30 days after that or earlier, the city you live in, will then update their tax record to reflect the new owner. So that's the general steps for completing this deed transfer while you're in beginning, middle, and end of refinancing the property. Let's go over the circumstance where you're not taking someone off a deed as part of the refinancing. You're adding someone to the deed. Now, why would you want to add someone to the deed? Usually perhaps it's a spouse. In that case, it would just make sense to add everyone to title because they'll have marital interest that attaches anyway, but not in that specific circumstances. The other reasons you might add someone to title is because you're contributing either credit, their income, they're contributing financial considerations that allow the refinancing to complete. Because if they don't join the refinance and they don't join title, then some lenders might not allow it to go forward. You can speak to your lender. Sometimes they'll let it go, just let them come as a co-signer, but perhaps they do need to come on title depending on the rules and regulations of the lender. Things you should consider as part of that element of it is if the person's only coming on for credit or income and they're not contributing to the mortgage payments, the utilities, the maintenance, then you strongly should consider what's going to be the mechanic if you go to sell the property in the future, because any refinances and sales in the future are going to require that person's approval. So you need to think through, is this a good fit, something you can work with this other person, and you're not going to get hurt financially in the long run with them also being on title to the property. You should also consider whoever you're joining on title, their likelihood of having legal problems. They have lawsuits, unpaid taxes, all those title problems will accumulate at the title to your house, and you wouldn't want to damage the ability to sell or the value of the property by the leads coming on through this other person that's joining title. You would also want to consider the framework of ownership. Typically, this could take a few forms. And by that, we typically mean in terms of the framework, whether the 2 owners or 3 owners or how many people are joining this new title, they are joint tenants with the right of survivorship or tenants in common. Tenants in common, that means both the owners have completely separate interests in the property. If one were to pass away, their interest would not go to the other one automatically. Their interest would go to the next of kin, either via general inheritance laws in the state you're in, or they will, or estate planning mechanisms in New Jersey where I am. So that's one. If that's tenants in common, then you have joint tenants with right of survivorship. That is when one person, the title on the deed, passes away and the property immediately goes to the other one. That can make sense in certain circumstances. Sometimes tenants in common can make more sense if you're bringing someone on to title at this time, but you would want to consult with a real estate attorney, an estate planning attorney particularly, to make sure whatever setup you're doing as part of this refinance makes sense for your special circumstances as part of it. Let's discuss, as part of refinancing real estate in New Jersey, several common mistakes to avoid if you are going through this process. First is nobody wants to waste time and money. When you're preparing these conveyance documents, such as the deed, affidavit of consideration, get rep form, any documentation that you need to complete this, you want to make sure that the attorney, the title company, and the lender can review these documents in advance. If you wait till the last minute to do it, it could delay the closing of your refinancing. So make sure all the parties respectively have a chance to review them, can flag any issues on each of their end, correct it in the conveyance in advance. So when you get to your closing of your refinance, you don't have any delays, stress, issues. You also, another mistake people make is downloading forms online and just using those. The problem with the online forms is that sometimes they're fine, but one is that they often miss critical steps. Examples of things they might miss is that if you're taking someone that typically when you're doing a transfer like this, if a person's coming off title and perhaps they were a spouse formerly, or maybe currently, they might have a marital interest in the property. And if you're not thinking it through as part of the transfer, for example, to put language about relinquishing a marital interest, then it could be a shock when you go to sell in the future if nobody asks those critical questions. So you want to make sure not to just use a form, make sure the deed has all the appropriate language to it. For example, I've seen deeds recorded without a legal description, which sounds crazy. But if you do not attach the legal description, sometimes the deed will actually get approved by the county. You've seen that. It creates a large problem in the future because the legal description is not there. So if you want to sell, if you want to refinance again in the future, whatever you want to do that may involve the title, then when the person evaluates it as part of title, they're not going to find the legal description. And then you're going to have to backtrack and do a corrective deed. They can have recording problems. So online templates, not necessarily the greatest way to go. You also want to evaluate legal risk in the future. For example, if you're just operating quickly, doing whatever the lender says to get the transaction approved, title company's not weighing in because it's not a formal sale, and maybe family members are not weighing in. So people just don't realize that even though it's not a sale, title issues, if you're doing a deed transfer, are essentially the same as part of the sale. So don't forget to have the title evaluated by the respective parties, because even though it's not a sale, and even though it's not a sale and it may not be you paying like a large down payment because you're refinancing, the legal considerations are the same as a purchase and sale transaction when you're doing this deed transfer, and therefore you should be thinking them through thoroughly. If you are engaged in a deed transfer as part of a refinance, naturally, any person getting a legal service is going to want to know how the costs are going to work. So let's just start with the legal fee. As of the month of recording this video, July 2025, most attorneys in New Jersey, where I am, are going to do a deed transfer on a flat fee. Most of the time, unless it's a really complicated situation, the legal fee is going to be less than $1,000. And so it will depend on the attorney, the complexity, but almost always it's going to be a flat legal fee, not hourly, and under $1,000. So under $1,000, depending on the quality of the attorney. If you're just doing someone that's not involved, perhaps that'll be on the cheaper end. But if the attorney is going to take a solid look at the situation, maybe it's closer to the higher end. You're also going to have recording costs. That payment is to the county. So to get those conveyance documents, the deed, get any other supplementary forms required for recording, including the new mortgage for the refinancing, that's going to be uploaded to the county. And then there's going to be recording fees for the county. Those recording fees depend on the number of pages that are being recorded, and then also on the size of the mortgage. So I couldn't tell you as part of this video how much. I couldn't tell you the exact amount. It'll be calculated based on those numbers when the time comes. Typically, it's standard. It's going to be less than $1,000 in record. Unless your mortgage is really high, it's going to be less than $1,000. Maybe if it's maybe $500,000 mortgage, maybe you're looking at $500. Last cost that you're certainly going to incur is going to be paying the title company. Usually the escrow agent title company is going to take the documents, the deed and supplementary forms, and they'll be the ones that upload them to the county. There's charges with that. The charges would probably be under $1,000, maybe $500, maybe $600, but the actual act of recording them should not be expensive. So maybe you are looking all in somewhere between $1,000 to $2,000 to fully compensate all the parties for completing the deed transfer while you are doing the refinancing.